Good afternoon. We have two cases on the call this afternoon. They're both arguments on the application. The first is People versus Kelli, Worth-McBride. Counsel, you each have 15 minutes. You can reserve some for, you brought your phone so you can keep track of time.
Well, and I'm hoping that it doesn't make some sort of embarrassing sound when I try to keep track of my time. Good afternoon, and may it please the Court, Christine Pajak, State Appellate Defender's Office, on behalf of Ms. Kelli Worth-McBride. I'd like to reserve 2 minutes of rebuttal, and I'm going to waive my free fire zone because I know we don't have a lot of time, and this case is difficult both legally and factually. Ms. Worth-McBride's son was killed by the baby's father, Josh Wilson. She attempted to intervene and was convicted of second-degree murder. And in theory, she could be if she had known that he posed an imminent threat, that she knew that he was going to seriously harm or injure the child. But on the facts of this case, the facts and the evidence presented in this case did not present this. There was a finding that she did not intend that the baby be hurt or injured, and her actions when she saw the baby being punched fulfilled that. The findings that Judge Lillard made with respect to the child abuse first are kind of contradictory, but the omissions cannot rise to the level where you would be convicted of first-degree child abuse. If you look at the language of the statute, omissions are covered under child abuse second, not child abuse first. I think there's this understandable desire is maybe not the right word, but nobody wants to see a baby killed, and that parents should be held responsible. And under certain facts, it could rise to second-degree murder, and the legislature could have made a decision to write the statute differently. There's a possibility, if one is reckless, of manslaughter, and that is historically what the parent's failure to protect has been given rise to our manslaughter convictions, not this sort of higher level of second-degree murder.
So, counsel, this might be an overly simplistic question, but why, when you read the first-degree statute and it doesn't require an act or an omission, it just says if the person, mens rea, causes. We know an omission can cause a result, right?
In theory, certainly an omission could cause a result, but you have to look at the entire statute, and the statute is written. The legislature defined omissions and defined them as failure to provide food, shelter, and willful abandonment. There's one other I'm missing in there.
Housing or no?
That's shelter, I think. But there's another one in there. And chose to punish those as second-degree child abuse. And that's a decision that the legislature made, and this court is not supposed to rewrite the statute. The prosecutor may want it to be something higher, but again, that's something for the legislature.
But is every omission... Does every omission possible under the law fit under those definitions? Is every omission a willful abandonment that's not a failure to provide food or shelter?
The legislature's the legislature has chose to define the omissions and put the omissions there.
Unless they chose to define the omissions that are prosecuted as second degree and left for first degree the omissions that are not included in that list, right?
I think you could. I think thinking about it that it is possible to put every omission under there. If you think of, say, shelter as a safe shelter, and not just like some sort of little hut or tent unheated, I think that would fall under a failure to provide shelter. And if you put that shelter in the middle of a pit of hungry lions, as it were, that would be also not a safe shelter, and so would fall under. You have an act, I guess, of building a tent there, but it's also an omission in failing to provide shelter. So I would say that if you look at the entire statute, and the entire statute is written, that omissions are covered under second-degree child abuse and not first-degree child abuse. We cited a case out of Massachusetts After that decision came out, the legislature in Massachusetts changed the statute and changed it to provide for specific punishment for, I guess, what you would call the passive parent, and chose to amend the statute to make it covered and to punish that person less harshly. And that's a decision for the legislature, and I would say that would be a decision here. It's certainly not that that person, can be held blameless. You still have the possibility of prosecution under other statutes. It's just not going to rise to this higher level. And I also would like to point the court to the facts of this case as well. I know the court is making law for the whole state, but in this particular case, there were a lot of the assumption that is made in the writing of the questions that were posed presupposes, knowledge on the part of the defendant, and the evidence that was put on here does not show the evidence. It's a really weak case, and a weak case in terms of showing what her knowledge may have been. The grandmother testified that the baby was fine. You don't have testimony from the eyewitness who was there at the time. You don't have this sort of exclusive access. There's no records from any medical provider, even sort of drawing the conclusion that that the judge did in terms of finding her guilty of first-degree child abuse based on her statement that she had tossed the child one time and therefore had then caused some of these healing broken bones, but at the same time using those healing broken bones as proof that she knew that he had injured the baby in this way. The prosecution made a decision not to put on the sort of evidence that may have filled those gaps. And the determinations that the court made were not reasonable in terms of a sufficiency finding that would rise to that level of showing that she knew that he posed an imminent threat. And if you look at the case law that's talked about imposing that responsibility on the passive parent, there's a lot more information that they have. It wasn't like he said, I'm going to kill this baby. She was there at the time and intervened at the time of what seems to have been the fatal injuries. You don't have that there were court orders telling them to keep him away from the baby, and she ignored those orders. You see those in the case law that has expanded the liability for parents in this situation. I think.
So just to specifically, I just want to. So specifically, if we disagree with you about first degree, and we believe an omission can serve as the actus reus for first degree, your argument is that the evidence here was not sufficient with respect to the mens rea. The judge didn't have any basis to find that that her omission knowingly caused the serious physical harm?
I think,
is that right?
That's right. And also, you have a specific factual finding by Judge Lillard. Again, it's a bit of a shifting target, but consistently, I believe there's this finding that she didn't intend for the child to be harmed.
She said that the judge said that twice, so I agree with you, but the statute says knowingly or intentionally. So I'm just focused on the knowingly.
Okay. So I think that there's a real failure of proof on the knowingly part in terms of the mens rea. One of the things the judge pointed to was that there were bruises all over the baby's body, but the medical examiner's testimony was that was contemporaneous with the fatal injury. So I don't know how that could have put her on, bruises that happened that day are not going to put her on notice. And broken bones that are only seen, according to the evidence in an autopsy report, are not going to put her on notice. She doesn't know what an autopsy is going to find.
Counsel, as best as I can understand the evidence here, defendant saw Wilson, quote, bear hug or, quote, throw the child on at least 7 prior occasions. I'm not precisely sure what that communicates on those 7 occasions. It doesn't sound like a good thing to happen to the child, but my question to you is, on any of those 7 occasions, where she personally witnessed it and was presumably at home at the same time, do we have any evidence that would suggest that she sought to ameliorate such conduct or to intervene in any way?
I believe that there are statements by her that she would tell him to stop it. And I think the missing her full statement, full statement, it's just a couple of written sentences, but that's my recollection of her statement. I think the other sort of missing piece here is that causing serious injury piece, that there is a failure of proof that on any of those prior occasions, she knew that it had caused serious injury to the child. That there's just this missing element of proof. There's certainly plenty of other people who were around this child. You had somebody there that day. The grandmother said she was there all the time, and that just a couple of days earlier, he was fine.
But you're saying there was evidence that, if only rhetorically, she told him to cut it out.
That's my recollection. I'll maybe double check it and tell you that on the rebuttal. But that's my recollection as I stand here at this moment. It's that missing piece of proof. You're really, if the court creates a rule that's going to impose criminal liability on parents to be this sort of perfect predictor of how the other parent is going to behave, you are putting people. This court has struggled with this question, right? It's been here before, and determining when there's going to be this criminal liability. You're now placing parents who are maybe struggling, usually younger parents with any other number of challenges, who don't want their children to be injured, and to know when they need to go and get court help and to go and find another apartment to do something, or they're going to face criminal liability. But if they're wrong, that can cut against them in a different way, and maybe the cost of saving a child's life is worth it. But there was a very high-profile prosecution in the state of a man whose 3 children disappeared. Skelton was his name. He's sitting in prison right now. He said he hid the children because they were being abused by the mother and wouldn't disclose where they were. And, are you then creating, you don't want to necessarily create a rule that is forcing people into that situation. That's why I think setting up a rule that requires this knowledge of an imminent threat kind of cuts that balance. It's not so easy to cut a parent out of a child's life. I think that light's coming on because I have 2 minutes left, although my timer says I have 3.
Yeah.
But that's why I think focusing very carefully on the evidence presented in the case and the seriousness of the charge. It's not that you can't prosecute them for manslaughter. It's just pushing it further, pushing it to a higher level of murder, pushing it to a higher level of child abuse beyond what the legislature contemplated. That is not supported by the law, and certainly not the facts in this particular case. If there are no more questions,
I'd like to ask one more question, please.
Of course, I don't mind.
You're concerned, as I understand it, by a circumstance or situation such as arguably we have here, in which a woman's or any spouse's deference to the other spouse may be an excessive amount of deference, supplication to the other spouse. It's not a desirable marital or any other kind of relationship between the spouses, but your concern is that where you have that kind of unhealthy circumstance with one spouse excessively deferring to the other spouse or being afraid of the other spouse or apprehensive about the other spouse, that could be transformed into the kind of criminal response that the defendant was charged with here.
It's not just necessarily too much deference, but it's at what point are you going to compel people to act? Or are you going to say, when you don't take steps here, you're not just negligent or reckless, your mens rea rises to this level of depraved heart murder that would be required to get to second degree, and that level of knowledge needs to be there. You want to cut that line, right, where you're protecting the child. Nobody wants to see dead children, but not placing people in this impossible situation where they're required to be perfect predictors without some evidence of, I would say, an imminent threat to the child's life.
is there evidence in this case that the defendant was not simply a terrorized spouse, an apprehensive spouse, and that she was more than just a bad actress?
I guess to make sure, you mean like was she actively participating in the abuse at some point? Is that the question?
Well, I think we know she wasn't actively involved in that, but was she unconcerned with that? Was she disinterested in that, or was her non-response largely a function, in your opinion, of the fact that she was afraid of the husband, the male here, or apprehensive toward him, or what?
I think that the evidence doesn't show, that there's statements that she's telling him to stop, that she certainly intervened at the point where he was hitting the child, and there was no statement made by her that she had seen that before. So, it could be partly a deference. It could be that there just wasn't knowledge that the child was seriously injured. I go back to the testimony of the grandmother who said that this baby seemed fine, despite the fact that the autopsy showed, a number of healing bones. Without any sort of explanation from a doctor to say you would expect to see with these injuries the child showing some discomfort, that there just isn't the evidence that she knew that he was seriously injuring the child. And when she saw something that was concerning her, she was certainly stepped forward. I mean, there's no doubt at the end that she definitely stepped forward. I see now that my light is on, so.
Thank you, counsel.
Thank you.
Good afternoon. May it please this honorable court, Madam Chief Justice. My name is Dan Hebel. I'm here on behalf of the plaintiff appellee, the people of the state of Michigan, and the Wayne County Prosecutor's Office. Now, we are discussing the rather grisly murder of baby Joshua, and the first point that I would like to make is that this wasn't a surprise. Not to defendant. Defendant knew what was going on because she witnessed 7 to 9 instances of abuse. Eventually, it was pulled out of her by the police that she did witness that abuse. And we know that this was not benign abuse and it wasn't mild abuse because of the type of abuse that it was and also because of the result of the abuse. First, the type. She admitted to watching the defendant throw the baby and also the co-defendant, Wilson. Defendant admitted to watching him throw the baby, and also she admitted that he would fold the baby, or as I described it in my brief, fold torture. Because what was actually described when she said bear hug was folding the baby in half and compressing the baby until he stopped crying because he couldn't breathe. So this was serious acts of abuse, and what did it result in? 9 healing fractures that were found at autopsy. Now, obviously, I believe that this case reflects another case that this court has dealt with, and I'm sure this court has seen the similarities as well with People versus Borum. And in the Borum case, which was dealt with by this court in 2014, Madam Chief Justice presented a hypothetical question which I feel really kind of defined the Borum case, and I also believe that it defines this case. And I'm going to quote that, and it is, if she, the defendant, were to take her toddler and drop her into a pit of hungry lions, would you concede that that's an act? And to add into this case, to be a little more fact-specific, I'm going to add to that hypothetical, does the location of the pit or the identity of the lion matter? Well, Your Honors, the people feel that those two don't matter. What matters is the act of leaving the victim with somebody that she knows is a lion. So we have 2 real questions. did she do the act of leaving the victim in the power and control of Wilson, the lion? And did she know at the time that Wilson was the lion? And the people ask that this court affirm because we feel that the evidence was sufficient in this case for a reasonable finder of fact to conclude that, well, yes, this was a lion, and it was a known lion that she was leaving the victim with. Now, there was a lot discussed with the question of whether this is an act or an omission. Well, I think, quite frankly, it's clear that this is an act. When you leave a location, there's obviously the physical act involved. But there's also a simultaneous legal act, which is leaving the child in the custody and care of somebody else. Now, we know that this is a perfectly permissible thing in most instances. Most acts or omissions that parents perform are part of their duties, part of their duty of care. Leaving a child with a babysitter is usual. Leaving a child with a known predator to watch is unusual, and it's not permitted as part of the duty of care. So when we're talking about what she did, she left she left the victim with her co-defendant Wilson, whom she knew was actively abusing the child. In fact, she knew that he had abused the child previously that same day, and he abused the child the day before. Now, speaking to her own mentality, her own knowledge, is the question of whether or not she was complicit, whether or not she had any idea what was going on. Well, we know that she didn't tell anybody about the abuse. We also know that, and I am going to cite to the record here, which would be in the Appendix 53A, that she specifically went up and tried to intervene during these episodes of throwing and fold torturing and told her co-defendant Wilson to stop. If nothing was wrong with this, why was she trying to get him to stop? We also know that when she explained to the officer that, oh yeah, well, she threw the baby once, she distinguished it from Wilson's abuse of the baby by saying, well, when I threw the baby, he wasn't hurt.
Can I press you a little bit on the going back to, I want to talk about the sufficiency as well, but on the first degree language, I asked sister counsel about why, if the statute doesn't mention omission or act, why wouldn't we interpret it to include both? I read your brief, I assume you agree an omission can serve as the actus reus for sub one. So but here's the flip side of that question. When usually in omission liability, we don't do causation the same way we do it with affirmative acts, right? And so when you have the language of the statute saying the person knowingly or intentionally causes the harm required, and I'm trying to sub in omission, so her failure to act, I'm trying to do it.
May I?
I swear I'm trying. Yeah, you do it. Yeah.
Her failure to protect her child,
Yep.
knowingly or intentionally, caused the outcome.
So wouldn't the statute, if it really wanted to include omissions in sub one, wouldn't results have worked better? I mean, well, it would be an easier case for you if the statute said if as a result of her acts or omissions, obviously that would make it really easy. This injury resulted. But there's something about causes which we, in most doctrine, in omission liability, we don't use that active causation phrase, right? We use the resulting harm.
Well, I don't believe that causation is necessarily an active idea. In fact, it's my interpretation exactly opposite. We have the legislative language of act, which we know that the legislature also defined to say according to MCL 75010,
Also includes omissions.
also includes omissions.
Right.
But act is a single deed. It is either a single act or a single omission. It is one thing.
Mm-hmm.
But cause is broad. Cause is any act, omission, or any other way of accomplishing a specific goal. If you cause something by omitting to do a duty, did you cause it? Yes. If you cause something by doing an action that accomplishes the same thing, did you cause it? Yes. Cause is the broadest possible language.
And what about the language in second degree? The specific omission language in the definition section, when it includes willful abandonment, I feel like you can almost assume any failure to act is a willful abandonment, right? You could describe the conduct here as willful abandonment, could you not?
I'm not going to disagree. I think that is possible. I think it's a reading that may not be necessary, but I do think it's possible, yes.
So how will we understand if willful abandonment, if the legislature intended that to be charged under second degree, what do you think the legislature meant to leave for first degree? What were the, you know what I mean? How is one answer might be the prosecutor gets to decide, and they may fail to prove the first degree, and that's on them. But I'm wondering how you think about what the legislature was thinking was something other than willful abandonment that falls under first degree.
When we're talking about willful abandonment in second degree, when we're talking about the, shall we say, omissions defined in second degree, we're talking specifically about we're talking about very specific omissions, very
I think you are until you get to
delineated.
willful abandonment, and then I think that means just about everything, including what happened here. So then that's what I'm
In
struggling
willful abandonment case law, Your Honor, it's usually, in fact, in every instance that I've ever seen, it is the parent leaving the child in a destitute position.
Mm-hmm.
Okay? I have never heard of a willful abandonment case
where a parent fails to protect a kid from a co-parent's
precisely.
violence.
So if you leave a child on the street, that's a willful abandonment. The issue between first degree and second degree is less about, let me restate this. The issue with second degree is the assumption of part of the mens rea. Okay? There are very particular types of omission. I'll give you an omission that doesn't fall under that category, and that is refusal to give medical attention. Does a parent have a duty to give medical attention to their child when reasonably possible? Yes. We see that in the common law consistently. That is a duty. An omission of that duty gives rise to actionable conduct which can be prosecuted under a variety of statutes. But right here, there's no way that could even be classified as an abandonment. So then, does it not count at all for the statute? But no, the specific parts of the second degree statute say these specific omissions, these special omissions, require a different standard of mens rea. In most of the other standards, and let's see if I remember this all right, they require a mens rea of accomplishing a specific goal, such as, like the first degree child abuse, you have to knowingly and intentionally cause something.
Knowingly or intentionally, that's important
Yes.
to you, I think, isn't it? Yeah.
That is important, and I apologize for that slip of tongue. In fact, one moment.
Can you go back to that? I appreciate that. I think you're making a really important plain language point about the mens rea requirement. So I appreciate it. I want to give you, before you run out of time, I want you to address the sufficiency of the mens rea in the court's findings with respect to the first degree child abuse.
Absolutely. The sufficiency of the mens rea is based on the facts. And a reasonable trier of fact, it's common knowledge that you're in pain when you have a broken bone. And the pain is evident. It's common knowledge that you're in pain when you have multiple broken bones. This child suffered from 9, and we're not talking about a particular area where it could be confusing. This child suffered from 2 broken clavicles, 2 broken knees, a broken wrist, and 4 broken ribs, all of which took place well before the day of the crime, many of which took place at least 2 weeks earlier. She witnessed him doing the conduct, throwing the baby, crushing the baby, that could result and would result in those type of injuries. So could a reasonable finder of fact conclude that she knew that when she went out, this would happen again? Yes, a reasonable finder of fact could draw that conclusion, and that's what we have here. In fact, the Court of Appeals said that it's implausible that she didn't know. And quite frankly, I agree. I believe that the people have shown, in a light most favorable to the verdict, and with all reasonable inferences taken in favor of the verdict, that defendant knew what she was doing.
Counsel, I'd like to ask you a few questions, and I realize that this is a very challenging and very difficult case, but I want to take a few minutes and just create a hypothetical, and I'd like you to kind of walk through it with me so I can understand the far-reaching implications of what we're trying to decide. I'd like to take the case that we have in front of us, but I'd like to change a few things. Would anything change if you had a situation where the spouse in the situation, I'm sorry, the mother in this situation was the victim of domestic abuse? So let's just take a hypothetical, let's change it up a little bit, where you have one of the parents, let's say in this situation, again, it's not part of this, but I'm trying to look at the far-reaching implications of this. And you have a situation where they're the victims of abuse, and the father says to the mother, if you say anything, if you do anything, I will kill you and I will kill your child. And she proceeds not to do anything in that situation because of the fact that she feels a sense of terror. How would that change the facts here? Because looking at the language and looking at the argument you just presented, wouldn't the same culpability and liability be present?
If I may, I notice that the red light is on. If I may respond?
Yes,
Of
please.
course. No, because I want to ask you a few questions. So.
Oh, well, thank you very
Yeah.
much. And I believe that changes things significantly. And as Your Honor requested, I would like to walk through this because
Yeah.
the first thing that we have is the issue of duty. And when we're talking about the common law duty of care, the language that keeps coming up in case after case is that a parent should take all steps reasonably necessary to protect their child. Okay? So that's the first thing, reasonable. Now, when we're looking at the mother in a severe domestic violence case, is it reasonable that she's afraid? Well, yeah, I think it's very reasonable. And I think, firstly, I think that changes the charging dramatically because in this particular case, we had a woman who covered up, who was laughing in interrogation about what happened to their baby. And then her attempts to cover up and minimize what happened, who was clearly, according to the facts, it looks complicit. When we look at a domestic violence case, we have somebody who is clearly a victim, another victim, and who is in a situation where it's reasonable that she would be too afraid to respond.
Let me change the hypothetical a little bit now. What if you have a situation where the mother is the mother's indigent, and if she says anything, she's going to be on the street with the child, and she still doesn't act? Then would that change just a little bit more?
Once again, we have a different scenario. And at this one, I think that there's a lot of discretion involved. There's discretion of the courts and discretion of the jury, because the question becomes, was her actions reasonable? Did she take reasonable steps to protect her child? Obviously, if she knew, if she had knowledge that, refusing to protect the child would result in great bodily harm or death, I think that she is not in a sure footing at that point.
How much abuse does the mother have to witness? I think we kind of gotten into this a little in the beginning. How much abuse does the mother have to witness to allow for a level of culpability to exist? I understand in this case it's a little bit more dramatic, but what we have to do at this court is we have to figure out what the principles are going to be for the 11 million people who live in Michigan. So what would the standard be? Like, let's just take another hypothetical. Like, is it 1 hit, 2 hits, the severity of the hit? How much knowledge does, one of the parties have to have in order to now be culpable for leaving the child with someone who is dangerous?
Your Honor?
Or allegedly dangerous?
Last answer, then we're going to move on.
Your Honor, I think that's an excellent question, and I think the answer is one that this court likes, and that is trust the fact finder. When there's a question of knowledge, how much knowledge is sufficient to show that somebody is being abused, whether it's 1 hit, whether it's 9 hits? The question is whether the fact finder sees that, yes,
Is there a
she
standard,
had
though?
knowledge.
How much so do we give unlimited deference to the fact finder, or is there a certain, is it just unlimited deference, or what's the deference that we're supposed to, total deference to the fact finder, or?
Your Honor, I believe that this falls back under the sufficiency question. That is, if a reasonable fact finder could reasonably conclude that, then this court gives the deference at that point.
Thank you, counsel.
Thank you very
Case will
much.
be submitted.